Okay, today we're looking at the significance of Section 109 in the Australian Constitution. So we're going to look at a section today. Okay, so it's study design dot point 3 in the study design, the significance or importance of Section 109 in the Constitution. So you need to be able to explicitly state what Section 109 is and what does it actually do. Now, if you haven't watched the video above, this section directly relates to the division of lawmaking powers, so make sure you go back and watch it. Okay, so what is Section 109 and how does it relate to the division of lawmaking powers? Okay, so a quick reminder, we have exclusive powers given to the Commonwealth, written in the Constitution. We have concurrent powers, which are given to both the state and the federal government, written in the Constitution. And we have residual powers, which are given or left over at the time of federation, and are usually given to the state. So Section 109 actually relates to concurrent areas of lawmaking powers. So how? Well, Section 109 states that if there is a conflict or inconsistency between the state and Commonwealth laws in an area of concurrent lawmaking powers, then Commonwealth law will prevail to the extent of the inconsistency between the two pieces of legislation. Okay, so we know that we have concurrent law where both state and the federal government can make laws in the same area. They may make a law that comes into conflict, and Section 109 can be invoked in order to fix that particular conflict. It means the extent of the inconsistency. What that means is it may be a word or a phrase that's inconsistent in the piece of legislation that may be struck out. Now, Section 109 isn't automatically evoked. In fact, two pieces of law can exist side by side that are inconsistent, and essentially they will continue to exist side by side until someone has a particular problem with it, and that someone needs to have standing or a reason to take this law to court. Now, if a person with standing comes to court, they will go to the High Court and they will challenge both the state law and the federal law, and state law will be declared void. Okay, so federal law will rule out over state law. So Section 109 is only evoked if it's taken to court. Otherwise, the laws can exist side by side. Now, Section 109 is explicitly mandated in the study design, so make sure that you know this section here and make sure you're able to explain it. Okay, so quick recap. What are the requirements? The provision of state laws that are inconsistent with Commonwealth law will be made invalid. So that means state law will be overruled by Commonwealth law. These laws can only happen, or Section 109 can only happen in areas of concurrent lawmaking, because that's only the areas where they can usually come into conflict. And in order for Section 109 to be evoked, it must be challenged in a High Court ruling by a party who has significant connection to the case. Okay. So it's good to note that Section 109 does not apply to the territories. Territories actually get their lawmaking powers from the federal government rather than the Constitution. There are something similar to Section 109, but you don't need to know that. But if you're interested, Section 28 of the Australian Capital Territories Self-Governing Act actually deals with inconsistencies between the laws of the ACT and other laws of the federal government. So there is an equivalent for the territories. But for you, you just need to know that Section 109 only applies between the federal government and the states. Okay, so what is the significance of Section 109? Or why is it important to know? Well, Section 109 can actually act as a restriction on states' ability to implement their legislative policies, as any areas or any areas of law that the Commonwealth Government shares with them will prevail if there is an inconsistency. So it may discourage states from making laws in a particular area if they think the Commonwealth Government has already made a law in that area. However, Section 109 is not automatic. It doesn't automatically occur, which means that states are able to make laws that may be inconsistent with federal law. Um, and this may encourage law reform, but states generally err on the side of caution when making a conflicting law. Section 109 is important because it does impose a consistent approach to dealing with conflict between the state and federal law. So it allows for some sort of consistency when these problems do arise and people feel like they're not sure which law to follow. Lastly, it's important to note here that if Commonwealth law is changed later on or it's gotten rid of, then state law can still exist and continue to operate regardless of whether or not the federal law has changed. Okay, that's it for today. If you're interested, and we'll do this in class, make sure you note the John McBain versus Victoria case as well. All right, see ya. Bye.